first matter to come before us this morning is State of Ohio versus Kyle Piatt. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, if you let me know when you get started, I'm keeping the clock up here and I can keep you apprised of the passage of time. We have read the briefs and we are ready to proceed when you are. Please be advised not to use names of victims or minors. Thank you.
Your Honor, please the court. My name is Eric Willison. I'm a counsel for appellant Kyle Piatt. I'd like to reserve 4 minutes if I could. And obviously, as outlined in the brief, there's a lot of problems here in this case. One of the primary problems, well, there's two, I think, main overall problems. One of which is that the individual problems that I've listed, but then within that, and related to all of them, of course, is the ineffective assistance of counsel issue. Such that the two kind of work together in some ways, that yes, there were errors committed, there were issues where objections were not raised to things, but at the same time, we are left with plain error. They've argued that I needed to somehow have asserted plain error in every single argument. I did assert it in the brief, as you saw in my reply to their memo contra, but it was sort of a blanket assertion of it near the end. I don't know of any statutory or case law authority that says I have to place that plain error statement in every single section of the brief. It just needs to be mentioned in the brief, so I wanted to address that. But what we have here is this sort of a synergy of unfairness, the disregard of the rules, the disregard of rules of evidence and things like that, the prejudice that occurred to Mr. Piatt, and all of it basically waved through the failure of trial counsel to get up on trial counsel's feet and say, hey, that's not right. There was a motion in limine, but as we know, motions in limine do not preserve rights on appeal. So once again, we have this issue where even if these things were somehow waived, the act of waiving that, we would argue, contributes to the ineffective assistance of counsel. Now, I guess one of the primary things is this issue of 404B evidence coming in, the other acts, the acts relating to the CPO, the violence that is alleged that Mr. Piatt supposedly had perpetrated upon her on other occasions. And she said basically that, the trial court said basically that even though it doesn't go to any of the enumerated 404B exceptions, it went to show her state of mind. Now, the problem with state of mind is that we're not talking about a rape case. We're talking about sexual battery. And we're talking about sexual battery under A1. And A1 specifically states that the offender knowingly coerces another person to submit by any means that would prevent resistance by a person of ordinary resolution. I think it's clear that that is not a subjective standard. That's an objective standard, ordinary resolution. Therefore, to go back and say what was this person's individual state of mind under A1, it's not an element. So state of mind doesn't have any relevance here, and it's not one of the enumerated exceptions under 404B. 404B also is a list of exceptions to the common law rule, and therefore has to be strictly construed against the state on this issue. Now, they did bring up the case of State versus Wright, I think it was, where the 4th District had said that in addition to the enumerated exceptions, there can be others. But those others still have to be relevant, is the problem. And that case out of the 4th District has only ever been followed for that proposition by one other case that I saw, which was in the 6th. And the problem the case itself cites to the Ohio Supreme Court's rulings, one from 1971, State versus Watson, where they brought in some evidence in a murder case that one of the suspects had stolen a gun from a homeowner in an altercation in a driveway. And they said, well, that's other acts evidence. And they said, well, this goes to show the line of possession of the gun, because they had to prove that there was a gun, because it was a felony murder case. But again, that was an element of the crime.
Would this show that she didn't acquiesce in the defendant's conduct along those same lines, though?
Well, this is what's very tricky about the distinction between rape and sexual battery. In rape, if you don't acquiesce, if you're being forced to, or you're doing this because of threat of force, then certainly that would be valid. But this isn't a rape case, this is sexual battery. And in sexual battery, it's my understanding that the person consents to the sex, but consents under circumstances that are unconscionable. Okay? And I think I talked about in the Bajaj case, I think was in my brief, where a doctor was basically engaging in sexual contact and conduct, and was the example was that with his power as a doctor to examine this person, they gave an example, a hypothetical example, I believe in Bajaj there. If a doctor had said, okay, I'm not going to treat your child unless you have sex with me, and the child has no other means of treatment, then that would certainly be unfair coercion that would overcome the ordinary resistance of any normal person. But, you know, this idea that the person can have a look in the person's eye that this person has seen before and knows what it means, again, that gets into a subjective standard rather than an objective standard. So that's a lot of the 404B. Now, the state has argued, well, but what about this other stuff where she was saying no? And what about this other stuff where he said, you're not leaving until I get what I want, and things like that? The trouble is he's not charged with kidnapping. And with regard to forcing her down or pushing her and all that, he's not charged with rape either. All those would be relevant to a rape charge. But the problem is he has no notice of a rape charge because he's not been charged with it. He has no notice of a kidnapping charge because he's not been charged with it. He has the right to be indicted for those charges under our system. But he was told you had consensual sex with somebody under circumstances that made it unconscionable, basically. That's what the statute, the sexual battery statute says. And so those aspects of it, I don't think we can rely upon those to say that that was the coercion. That's force, that's rape, that's kidnapping. Those aren't on the table here.
Are you conceding the notice argument under 404?
Again, this is something where they should have been provided with notice, but once again, trial counsel just didn't object to it. She didn't object, and the state has made an argument, well, maybe that was tactical. What is tactical about that? It's, the same issue came with the failure to object to the leading questions that were being asked. And they said, well, maybe that was a tactical reason for doing that. What possible advantage could you have as a defense attorney to allow the prosecutor to go through and ask, just lead the person right through the elements of the case? In their opening argument, the prosecution, Mr. Cooper, had talked about how we're going to show evidence that these things were, that the look that he gave her was burned into her memory and she'd seen this look before and they affected it. Well, you're going to hear evidence of this, ladies and gentlemen. And then when it comes time for that evidence, he actually asks those questions. And this look was burned into your memory? Yes. And you'd seen this before, you know what happened? Yes. So he's taking the central core of his case and getting it in through these leading questions. And yet, that's tactical on the part of defense attorney, who just sat there other than raise 2 objections to different things, but it wasn't about this. So again, to the extent that that happened, that's both an error for the court to allow these leading questions, but also an error as far as it can't possibly be tactical. It's ineffective assistance of counsel. It is true that judges have the right to, or I shouldn't say the right, the power to allow leading questions in. But generally,
answer my question. I was just
yeah,
going to ask.
right. See how I can anticipate this? The learned look, I knew it. The problem with that is, though, that we generally see this with little children or people who have trouble testifying for some reason. Maybe the person has a hearing difficulty or whatever. The state says, well, it's okay if it's there to develop testimony. Everything is here to develop testimony. Everything is here to develop. It certainly would be easier to ask all leading questions at all times to develop testimony, but you've got to show some reason why that's necessary. If we've got a 6-year-old who's kind of not really looking to say something about dad when he's sitting right there, or a battered woman who is a little bit intimidated and things like that and can't really get it out, but she was having no issues about getting these things out. She was not having a problem testifying in any way, shape, or form. So this idea that this was necessary to develop testimony, there was no evidence of that. You can't just say, well, I just wanted to get it out because it's easier that way.
And counsel, you are just now reaching that 4 minutes. You can continue or reserve the full 4 minutes.
Okay, one last thing on this would be the issue of the judge's statement about how disgusted he was with the appellant. It is true that he did not make the decision as to guilt or innocence. That was the jury. But he did make the decision as to the sentencing. Okay, they make the idea. They point out that, well, there's no power of this appellate court to disqualify. But I'm not sure that I understand that the normal way to do it is to file an affidavit of disqualification. But during trial, you stand up and say, Your Honor, hold on. Got to run to the Supreme Court, file an affidavit of disqualification. I'll be back in a day or two. Maybe they'll rule by then, and then we can pick up the trial again. I don't think that that's the way that works. So I'll reserve the rest of my 3 minutes or whatever now.
Thank you.
Good morning. May it please the court, counsel Andrea Uller from the state of Ohio. The state's position that this court is not required to consider the constitutional issues raised by Mr. Piatt for the first time on appeal, nor is this court required to create a plain error argument on Mr. Piatt's behalf. In the present matter, Mr. Piatt has acknowledged that his trial counsel failed to object on any of the grounds complained of on appeal. However, Mr. Piatt has now raised constitutional issues for the first time on appeal, and although he asserts that he engaged in the plain error analysis, Mr. Piatt failed to demonstrate that but for the alleged errors, the outcome of his trial would have been different. The question of the constitutionality of the statute must be raised on that first opportunity, which means at the trial court level, and as this court's aware, when that failure to object on that constitutional issue is made, the appellate court simply need not consider the objection. With respect to the issues with the plain error, then of course this court has held that it will not sua sponte engage in that analysis, but I will proceed as though all arguments are going to be analyzed. So with respect to the points that Mr. Piatt's counsel has made here this morning, with respect to just his statement of the individual problems that occurred at the trial level, when you look at the appellant's brief, the individual errors could basically be, the alleged prior bad acts testimony under the 404B evidence coming in, as well as the failure to object on that basis, as well as just the failure to object to other complaint of errors at the trial court level or to raise these issues. But those individual problems, he has not actually asserted and done the analysis to say that that amounts to that, the doctrine, now I'm going to blank on it, the cumulative error doctrine. And so I don't think that we can, look at those individual problems isolated, and then take them and do the cumulative error doctrine, because there are simply no objections and no errors made at the trial court level here. But also it's well known that that doctrine of cumulative error just does not apply when there are no errors. With respect to the 404B argument, undertaking the plain error analysis, it cannot be said that but for the admission of the prior bad acts to show the victim's state of mind, the outcome of the trial would have been different. As counsel has acknowledged, Mr. Piatt filed a motion in limine requesting to exclude in part all prior bad acts testimony, and there is a lengthy discussion in the trial transcripts, basically from pages 3 through 20, that's the trial court's ruling on that motion in limine. And the prior assaults against the victim came in this case because the prosecution argued that it was relevant to the element of coercion and the trial into the state of mind, and the trial court agreed with that assessment at page 5 of the transcript, stating that given the nature of the offense, it goes to the state of mind of the victim. The trial court further stated the evidence or testimony of the defendant having choked the victim while she was pregnant also came in as that prior evidence towards that state of mind. With respect to the civil protection order, the trial court and prosecutor also agreed that that would also go toward that state of mind. And in the brief, I've cited to State v. Duke, which is a 5th District Appellate Court case where the appellant claimed that the trial court had erred in permitting prior bad acts into evidence, but the evidence was permitted by the 5th District on the basis that the complaint of testimony explained the victim's acquiescence to the abuse. The same is true in this present matter. The victim did not loudly shout no. She did not try to run with her child. She did not claw or use force to ward off Mr. Piatt. Instead, she said no repeatedly. She pulled her legs up in an effort to make it difficult for him to sexually batter her. The victim testified to the look that she saw in Mr. Piatt's eyes, a look that she testified she had seen before, while being choked, and that she just tried to get through the 10 to 15 minutes, and that she left crying, with Mr. Piatt following her to the car, repeating, "Please don't do this to me. I'm sorry. I just needed to feel like a man."
Was that case you cited also a charge of sexual battery?
It was the sexual battery in Duke. At least that's my recollection. In State v. Wright, which was also referenced here, the 4th District has ruled that other acts evidence can come in for other elements or for other purposes than what's set forth in 404B. The state acknowledges that state of mind is not one of those exceptions, more so under 404B. But in this case, the 4th District said that any other evidence can come in for other reasons than those listed for evidence 404B, provided the evidence is not solely to show the accused's propensity. This evidence wasn't to show the propensity, it was to show why she reacted, because the argument was made again and again that a look can't coerce you, and that it has to be on this objective standard of how any person would feel when they're, that they would have had to have submitted to Mr. Piatt. Well, when you look at 290703 A1, it is no person shall engage in sexual conduct. When any of the following apply, the offender knowingly coerces the other person to submit by any means that would prevent resistance by a person of ordinary resolution. So if we take this, even if it's not, the victim in this case, the Duke case says you look at, her testimony is relevant as to that physical and mental abuse that she's endured, why her reaction is what it is on that day at that moment. And so when we, if we take the victim out and we put another victim in these same circumstances, when you've been leveled with a look while being choked before, when you're outweighed by 50 pounds, when you know that your assailant, it has a black belt in karate, all of that comes in, and I think that you meet the elements under that 290703A1.
To use that evidence, did the state didn't the state need to provide notice
There is,
pursuant to the rule?
yes, Your Honor, under the rule, it says that you should give notice in advance.
Shall
and
give notice?
Shall, yes. But once you know, and this one I did not see on the record anywhere that that notice was provided. However, as I've stated in the motion in limine file, it addressed all relevant instances of those prior bad acts, so that although
Yeah, but
the
isn't there a
state
difference between knowing the state
may,
possesses other act evidence and knowing the state intends to use other act evidence against you? Is that the purpose of the notice?
yes, I agree that there is a distinction there and there is a difference. However, it ultimately comes down to the trial court's discretion as to whether that, violation is, warrants that the other access testimony coming out. There was no objection on that basis at the trial court level. And, when you combine that with the fact that they were prepared for the possibility that all of this other acts evidence would come in, I think that, that they should have forfeited that argument on appeal then. With respect to the element of coercion, I think that's the bigger element of this whole case. To me, and I've tried to brief, the definition of force is broader in the sexual battery context than it is in a rape case. And so that means that all types of force count. And so, to say in this case that it relies on, consent, I don't read 190703 as saying that you're not consenting just because you have to submit by by force or being coerced. That's not consent. And you look at that overall definition and how coercion is to compel another by pressure. I think there is sufficient evidence in this case that this victim was compelled by pressure to endure this. Moving to Mr. Piatt's second assignment of error. Again, this is with respect to the leading questions. Evidence Rule 611C permits leading questions, provided that the questions should not be used on direct examination except as may be necessary to develop the witness's testimony. No specific instances of the leading questions were actually set forth in the appellant's brief. However, looking at the overall transcript, there are always going to be instances of leading questions, and when you're looking at the look in general, the state's questions were directed at just trying to get the witness to convey what that look meant to her, why she felt that because of the prior instances, and there's no number of leading questions, no limit on the number of leading questions that a party can ask, and the trial court ultimately has that discretion to allow the leading questions, and again, there's no objection made. And I believe the appellant had referenced State v. Bump, but in that case, the prosecution supplied a substantial amount of the testimony for the witness, and you can't say in this case that this is the case where the prosecution testified. The victim in this case she was, as counsel had said, she was able to elaborate on her answers, and then it was just more to kind of help develop that testimony. With respect to the constitutional issues, if I may jump to the third and I believe it might be the sixth assignment of error. But again, I apologize, Your Honor. Actually, the third assignment of error was about the trial court being biased or prejudiced. And to touch briefly on that, as I have stated, it is the proper procedure. You didn't put that in the brief, but as counsel has stated, to file that affidavit with the Supreme Court when you have this judicial bias or prejudice claim. But because that didn't occur, and the case law is that you actually, an appellate court has no authority to determine such a claim. Instead, the authority that this court would have would be to look at the bias statements at sentencing, to look at them for due process violations. The complaint of statements here occurred at the during the trial, outside of the presence of the jury, the trial court did, discuss with both the defendant's behavior and the victim's behavior, mainly in, relation to that protection order. And essentially, when we get to sentencing, the trial court acknowledges that it had expressed displeasure with both of them, but it says that, it finds the victim's testimony that it was very credible, and it found that the defendant's, actions were very reprehensible, and he found that, the defendant showed a lack of remorse, and it was still more so about him than it was, the victim. There was no responsibility for that action, and imposing the maximum sentence, that the sentence imposed was in compliance with the law, so it was not contrary to law, and so Mr. Piatt's third assignment of error is also without merit. With respect to the constitutional arguments, it seems that Mr. Piatt is, challenging the statute as applied to him, mainly because of this, the coercion element, and that a look cannot lead to coercion. But as I pointed out, the first step to determine whether 290703A1 is unconstitutional as applied to Mr. Piatt is to step back and ask, does he have a constitutionally protected right to engage in the behavior he engaged in? There's no First Amendment protection, to engage in sexual battery against another, to coerce another knowingly, to knowingly engage in sexual contact with you. And so, and in addition, the fact that Mr. Piatt's argument hinges on the look in his eye, I would reiterate that throughout this case, she also testified about, that past abuse, how that look affected her state of mind, and again, that coercion for sexual battery purposes, it is broader than the force required in rape, and it is understood in sexual battery context to mean to compel by pressure. And so looking at the facts, it cannot be said that 290703A1 is unconstitutional as applied, to him on the specific facts of his case, nor can it be said because coercion is not defined in the revised code that he was not on notice. He later argues that more or less he wasn't on notice that this conduct would be prohibited. But I think that, the end result in this case, if you step back even from the fact that if he didn't know that the look in his eye was, coercion, then the fact that he kept advancing when someone is telling you no and trying to resist, and someone is crying and they leave crying and you acknowledge that they're upset and you apologize, I think all of that also goes towards you had knowledge of the prohibited conduct.
Counsel, you have about 5 seconds.
Okay. So overall, it's the state's position that this court does not have to consider the plain error arguments or sua sponte raise them on his behalf, nor is it required to consider the constitutional issues. Thank you.
Thank you. Counsel, you have 3 minutes and 11 seconds for rebuttal.
I wanted to address, there was a case that out there from 2018 called State versus Moore, and it's 2018 Ohio 1825. Does a very, very good job of going through the issue of the manifest weight of the evidence and all the standards and all of that. And it talks about, when there's a he said, she said situation, there's no forensic evidence, the effect that has. This wasn't quite a he said, she said case, because there were some neutral fact witnesses that actually said, that contradicted what she said. There were people sitting outside the camper that said that she went in, and then she came out of the camper and went into the house. Presumably they figured to go to the bathroom, since it was just in the driveway. This wasn't like hooked up to anything. And then she came back out and went back into the camper again. She never said that. And then they also said that she said she was crying when she left, and they said on both times they saw her leave the camper, she was fine. To answer a question you asked earlier, Judge Teodosio, Duke was both a rape and a sexual battery case. It was a father-daughter sort of thing, with that sort of thing. With regard to the leading questions, I mean, if you look at page 23/24 of the jury trial transcript, The prosecutor asks, so this look was burned into your memory? Yes. And then when she forgot to mention that she was telling him no, he said, so, but you rebuked him, right? And that's on page 40. And she says, well, yes. And then earlier, or later on page 41, he says things like, and this look he gave you, this was the same look he gave you when he choked you earlier? I mean, he's leading her right through, and she's saying, yes, that was page 41. So all of these things, like I said, there can be no possible reason for this to be a tactful decision not to object to these things.
How about the argument that it didn't change the outcome given her testimony?
Given her testimony, and again, this was, as the judge acknowledged in the sentencing, this was a credibility case. And this was her word against his, but there were two witnesses that gave a different account of what she said. And so balancing that, and it's sort of a, you don't know who to believe and you're a juror, but gee, this guy's choked her and beat her and done all these things to her before, you know, that's tremendously impactful in a case where it's simply her word against his with delayed reporting. There was evidence that there was a child support, or not child support, a child custody matter that was brewing up right around the time of this that was brought in by the trial counsel. So in a situation where there's no DNA evidence here, there's no sane nurse, there's no anything. She leaves, she sends him naked pictures of herself a few days later after this. None of this makes any sense.
Counsel, you have about 5 seconds.
Okay. With that, I conclude. Thank you,
Well
Your
said.
Honor.
5 seconds.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a decision which will be mailed to both parties, as well as posted on the Ohio Supreme Court website.